Good afternoon, and thank you for joining us here this afternoon. I'm here to announce the results of a motion hearing that was held here on June the 15th, 2017, wherein Mr. Malvo appeared through counsel before Judge Robert A. Greenberg on a motion to correct what he captioned as an illegal sentence. In an opinion that was filed today in the Circuit Court for Montgomery County, Judge Robert A. Greenberg, who is the chief of the circuit here in Montgomery County, denied Mr. Malvo's motion to correct an illegal sentence. Those sentences were handed down in connection with his 2006 convictions for 6 homicides that occurred in October of 2002 here in Montgomery County. The decision of Judge Greenberg today affirms that Mr. Malvo was properly sentenced to a maximum sentence available for his heinous acts, 6 consecutive sentences of life without the possibility of parole. Each one of those sentences was related to one of the 6 murders for which Mr. Malvo was convicted back in 2006. As I'm sure most of you know, Maryland had repealed the death penalty as was applicable to minors prior to Mr. Malvo's case, so the sentences given were the maximum amount allowable by law at the time. In today's opinion issued by Judge Greenberg, the court found that the original sentencing judge, the Honorable James Ryan, now retired from this court, reviewed all of the relevant information and made the appropriate sentencing determination in this case. Judge Greenberg found that Judge Ryan did in fact review appropriately the pre-sentence reports, heard from family victims and members of the families of those who have been slain, and of course he considered the sheer brutality of the crimes in which Mr. Malvo engaged. Judge Ryan also was found by Judge Greenberg to have given full consideration to the physical, mental, and emotional state of Mr. Malvo at the time, despite the fact that he had not yet reached his 18th birthday. Critically, Judge Greenberg stressed that the sentencing scheme that existed in Maryland gave discretion to Judge Ryan to determine what the sentence should be. This was not a scheme, this was not a sentencing law that required or mandated life without the possibility of parole, but allowed a judge, upon proper factual findings, to give that sentence if they deemed it appropriate. Judge Ryan weighed the appropriate facts and gave those sentences. The court's opinion, and you will receive a full copy of the court's written opinion, squarely rejects each and every one of Mr. Malvo's assertions set forth in his petition to set aside his original sentence. The court considered and rejected the application of 2 Supreme Court cases. After Mr. Malvo was sentenced in this case here in Montgomery County, the Supreme Court in 2 cases, Miller and Montgomery, dealt with the issue of mandatory life without the possibility of parole sentences for those who are convicted of crimes while still minors. Those cases said that the sentencing structures that mandated that if you're convicted of crime A, you must be sentenced to life without the possibility of parole was a violation of the 8th Amendment. Maryland doesn't have that sentencing structure. Maryland does not have a mandatory sentencing structure, and Judge Greenberg found that the Miller and Montgomery cases do not apply to the Maryland sentencing structure under which Mr. Malvo was sentenced. The essence of those cases that were being reviewed is that life without the possibility of parole should only be given to minors in cases that involve the most egregious kinds of facts. Quite candidly, that's precisely what Judge Ryan found in this case. In total, there are 3 important rulings that were made in the opinion issued by Judge Greenberg today. 1, Mr. Malvo's challenge that his sentence was illegal was not well-founded. Mr. Malvo's sentence, as originally given by Judge Ryan, was perfectly legal. Under the law in the state of Maryland, it was not an illegal sentence. Second, even if Mr. Malvo's sentence was subject to a constitutional claim, the facts that were found by Judge Ryan are such that it would satisfy the new constitutional standard. The bottom line is that the Supreme Court cases don't control here, but even if they did, the facts found by Judge Ryan would hold that the sentence of life without the possibility of parole was the appropriate sentence. The bottom line is, any way you analyze this case, this is a complete loss for Mr. Malvo. The challenges that were raised, the statutes, or I'm sorry, the case opinions that he relied upon don't apply. His sentence was not illegal. And even if the new law did apply to him, and Judge Greenberg found it didn't, the findings by Judge Ryan would have satisfied even the new law. So however you analyze it, Mr. Malvo loses. And the sentences given by Judge James Ryan back in 2006 were upheld as legal, constitutional, and fully in compliance with Maryland law. I want to thank Brian Kleinborg, who formerly headed the Criminal Appeals Division of the Attorney General's Office here in the state of Maryland, who's been a member of my staff closing in on about a year and a half or 2 years, who argued this case before Judge Greenberg. I want to thank him for his extraordinary work on this case. We also want to remember, and I want to thank Judge Ryan. Judge Ryan was a fabulous member of the bench here in Montgomery County. And quite candidly, even though Judge Ryan's sentence was being challenged by under laws that did not even exist at the time that he gave these opinions, Judge Ryan covered the bases so well at the time of the original sentence. It was almost like he was omniscient and saw where the law was headed, and he made findings that made sure that these sentences would stand the test of time, and they have. And so we want to thank a wonderful, now retired judge for the way he conducted this trial and the way in which he conducted the sentencing in this matter. We are very much grateful to Judge Greenberg, our new administrative judge. Judge Greenberg got it right. I think that you will find that his opinion is well-reasoned, extremely well-written, and I think it addresses every issue raised by Mr. Malvo and his attorneys at the time, and rejects each and every one of the bases upon which Mr. Malvo attempted to gain relief in this case. I was the legal advisor to the Sniper Task Force back in October of 2002. Some of you don't, I guess some people have moved into the county since, but anybody who lived here in October, in those 22 or 23 days, life was never the same before or since. And historically, if you know that what was happening here initially when it took place in October 2002, it was almost a year to the date after September 11th in 2001. We thought we were under a terrorist attack in this community. Everyone lived their life differently. If you were a young child that was we suspended football games and cross-country meets, and your kids couldn't play outside. And I know we were rapidly approaching Halloween, and people were talking about taking their children out of town to trick or treat because this so fundamentally changed that way we lived as a community. The sentencings of Mr. Malvo and making sure that those are secure sentences and they remain the sentences in this case are so important because this case was so important to the men and women of this community. We are very grateful to the trial teams and the lawyers who represented the government back at the time, Vivek Chopra and Catherine Winfrey. They did a fabulous job presenting this case against Mr. Muhammad. And I will tell you, look, Judge Ryan just didn't willy-nilly give this original sentence. As many of you know, in addition to the fact that Mr. Malvo actually pled guilty in his cases, he testified against his co-defendant. He testified against John Muhammad, who was tried in a case right above where we're standing over several weeks. And he was found guilty of 6 murders as well, the same 6 murders that Mr. Malvo pled to. And Judge Ryan said, I consider, Mr. Malvo, that you did in fact cooperate with the government and you testified against your co-defendant. But even despite the fact that you did that, the crimes were so heinous and so deliberate and so premeditated, the sentence that I have to give is life without the possibility of parole. Judge Ryan considered the lack of remorse, the nature of the crime, the number of the victims, the victim impact, and every other relevant factor. And again, the law has been complied with. People should have faith that justice was done originally at the time of the trial, at the time of the sentencing. And again, we're very thankful to our new administrative judge, Judge Greenberg, for his well-reasoned and thoughtful opinion that you will have a full copy of so that you can study that for yourselves. With that, I'll take a couple of questions.
7 News Channel 8.
John, I'm learning Judge Greenberg is out of your office.
Yeah, can I tell you, I think this was important to the community. And so were we relieved that we hopefully this will be the final chapter of us having as a community to look at this case? I think the answer to that is yes, we have some relief. But look, more than this is, I think this is a case that's important to the community. That's why you're here. You know, we're 13 years removed and you're standing here as if it happened yesterday. Why? Because if you're a member of this community, you know how important this case is, and that's why we're here gathered today. So we are thankful for a well-reasoned opinion. You know, as soon as Kevin, when these Supreme Court cases first came out, I knew that our sentences were mandatory, not mandatory sentences, but life without the possibility of parole, discretionary sentences. I didn't think that Miller and Montgomery governed the Malvo sentencing. And I will tell you, when I first read the Supreme Court cases when they came out, I thought immediately of Mr. Malvo. And look, I'm not surprised that somebody did not try to misuse those new legal precedents to try to get a resentencing in this case. But I am very thankful that I think the analysis done by Judge Greenberg is completely consistent. Those cases analyzed mandatory sentencing requirements for life without possibility of parole. Here, Judge Ryan had discretion, looked at all relevant facts, and made the right decision based on a totality of the circumstances. That's what the new law requires, but that's what Judge Ryan did even before it was the law.
WJZ out of Baltimore, 13.
You ever worried about this decision when it comes through? Like if you would get a new sentencing, you have any doubt at all throughout the process?
Well, having been doing this for about 40 years, some things don't turn out the way you think they're going to turn out all the time. Look, Judge Greenberg is a wonderful judge. I think we had a wonderful hearing. I think that some of the comments made by the judge, we were hopeful that the judge was accepting of our logic. But again, you know, we were confident in terms of what we thought the law was and should be and how it should be interpreted. We are grateful for the court's ruling. We were very optimistic. We were optimistic from the very beginning. But again, until you receive that opinion and you see what the judge's rules, you know, been around long enough that it's not done till it's done. Yes, the answer is yes. One of the things that we battle with in the area of criminal law is bringing finality. Does Mr. Malvo have a right to further take an appeal from this case to a higher court? The answer is yes. I will tell you, I think the way Judge Greenberg wrote the opinion really solidifies our position. Because again, he made two rulings. Number one, the sentence was not illegal. Number two, the Supreme Court cases don't apply to Maryland because they are discretionary, not mandatory. And three, and this is, I think, the bottom line, even if the new law did apply, Judge Ryan, if you read his comments at the time of the original sentencing, would have satisfied even the new law if it applied, even though I think it doesn't. So it just sort of, it's kind of, if there are two ways or two options for the defense to pursue, I think Judge Greenberg's opinion effectively ends those appeals because he cuts them off in either direction. So I'm hoping that he has an appeal, but I think there's some finality here.